I'm Stuart DRESNER, Chief Executive of Privacy Laws and Business, and I'd like to welcome you all to Privacy Laws and Business's 26th Annual International Conference. It's here today, over the 3 days, we're a group of 200 privacy people from 16 different countries, and I often feel that in my role as a Chief Executive and at this conference, I'm like the curator of an arts festival with exciting sessions in all different places and in Queen's College. This conference obviously is a combination of location, people and content. Of course, content first, but location helps. You may have noticed in our early promotions to this conference, the trees were covered in frost. We had to wait till about June till we got a picture of green leaves, but fortunately that's arrived and we're here now. Bridging privacy cultures. Where are the laws? How many are there? Where are the next laws likely to be adopted? Before we consider how we bridge the privacy cultures, we need to look at the countries where there are the laws and the bills, and we're going to look at them in the form of maps. And this work is based on a huge research project conducted by Professor Graham Greenleaf from the University of New South Wales, who is also our Asia Pacific editor. He comes here some years, but not all years. So this is a new set of maps which will be available on our website, and we put them together just for this event. So you can see virtually all of Europe has data protection laws, and for this purpose we've included Israel, you can see there on the east, which has EU adequacy, Morocco on the left, which is moving towards joining the Council of Europe, signing and ratifying the Council of Europe Convention, and Tunisia has a law, but I think it's done neither. It's certainly not, I don't think it's gone to either extent yet. Lots of changes in Asia. There's a new law adopted in Japan just 5 weeks ago, on the 24th of May, which was to do with the ID number system. And it's rather important because the Act mandates the government to make changes to the current privacy regime, to establish an independent supervisor, to conduct information impact assessments, and decentralise the management of ID numbers to avoid privacy risks. So an important point here is for the first time established an independent data protection authority in Japan. China has a series of different laws. We're going to hear more about that in a parallel session today. And India does not have a comprehensive law, but has various bits and pieces.
Although privacy has so many meanings around the world, what is common is they all relate to shared aspects of the human experience. We all as humans need some privacy. Privacy laws around the world are based on widely accepted basic principles, such as limiting collection and only using personal information for purposes for which it was collected. Although I say that knowing that this central tenet is being challenged by the rise and the allures of exploiting big data. There's plenty of common ground that will help pave the way for greater cooperation, even if our different approaches do result in a few bumps on the road. But different historical approaches mean that the architecture of privacy laws also differs. For example, we see differences in how important concepts are defined. What is personal information? What does constitute meaningful consent? We also see variations in the obligations imposed on organizations and also in the scope of national laws. At times, these contrasting doctrines can result in friction, as we have recently seen in the transatlantic back and forth over proposals to update the European Union privacy framework. The EU, as I have said before in other circumstances, leads the way in defining the standards of data protection and in articulating central issues for individuals, such as the right to be forgotten. Hence, it may not be surprising that the draft General Data Protection Regulation apparently ranks, what I read, among the most lobbied legislation ever introduced into the European Parliament. While I can find it often disheartening to watch the sometimes very bitter debate unfold, I remain cautiously optimistic that positive developments for privacy cooperation will ultimately emerge.
As often happens, it's the lay politician that has to call the tune on negotiations, and therefore I'm genuinely very pleased to be here at this Cambridge conference. And I can only pay tribute to the foresight you had over a quarter of a century ago in recognising the importance that privacy would play in political debate at this time. I think we can say that you've anticipated the zeitgeist in a quite remarkable way. We all know that we're at one of those pivotal moments where the decisions made in the next year will significantly shape the data protection landscape for possibly the next quarter of a century to come. And the question, therefore, is how will history reflect on the work we're doing now? Will we have a data protection framework in place which it successfully anticipated technological and sociological and societal developments, possibly things that are beyond even the wildest imagination at the moment in time? The discussions being held here this year are more relevant than they've ever been. I'm therefore very pleased to be able to contribute to the ongoing debate on data protection. And could I thank the other speakers who have travelled from around the world to be here during this three-day conference. Ministers and governments need all the help they can get in getting the balance right. I might even add, and commissioners do as well. We need to be able to balance the legitimate concerns of the individual citizen that their data will not be abused either by agencies of the state or by private companies. Yet at the same time, we mustn't strangle at birth the enormous potential of the digital economy by over-regulation and stultifying bureaucracy. These are big issues, big decisions. And what better place to discuss these issues than Cambridge? We all know that this is one of the global centres of high-tech business and has emerged as a key enterprise hub that helps to enhance our digital economy. We can be very proud that we have our own version of California's Silicon Valley right here in Silicon Fen. It is therefore important that business here, as well as right across Europe, are given the opportunity to innovate and prosper.
Now, some people have recently started to think, wait a minute, is this a problem? There are so many different pieces of guidance out there. Do they conflict? Do people understand how they should apply? Do we just have too many of them, right? And in general, I want to reassure you, there are some vast similarities between all of these efforts. They're all focused on general fair information principles. They for the most part, all talk about notice, transparency, right? How you discuss the ways that an application is using information, particularly around things that might be unexpected, like your torch that's also, collecting all of this other stuff about you. How you can create that transparency in a mobile environment. They all talk about choice, where appropriate, particularly around unexpected uses or what we would traditionally call secondary purposes. Most of them talk about things like defaults, how defaults should be set. They encourage privacy by design. Application developers should be thinking about building privacy into the way that the application works rather than trying to append it afterwards with some lengthy privacy policy or terms and conditions that, frankly, probably nobody in this room even reads, much less the layperson on this. Some of them have specific guidance around things like location, things like children's information, things like social networking and other social features. They're all useful guidance, and they're all saying roughly the same things. And in general, none of them promise that following the guidance will give you compliance with the law, because that's not what they're there for.
Efforts have been made and will continue to be made to build bridges across the Atlantic, but also elsewhere. And perhaps this is all the more urgent today than ever. But there's two things that I would say, first things first. I'm not sure what the first will be, but first of all, the issue of PRISM needs to be cleared in this sort of transatlantic discussion anyway. Even if it is an issue of national security, it does impact European citizens' privacy and needs to be addressed. There may be consequences for the Safe Harbor Agreement. In any case, I'm sure you are aware of the impact of this on the discussions on the regulation. For example, already talked about the so-called Article 42, whether it should be in the regulation or not. But leaving apart this important new subject, there is something else that we need to do first, and that is to get our own EU house in order. This morning we've been talking about it. Directive which precede the internet age. Basic principles of the directive have stood the test of time. There is a need to move forward and ensure the European legal framework is fit for the future.
Now, this is not as complicated as it looks. At least we're not going to talk about all the permutations. This is actually a simplified representation of the three main layers. I mentioned infrastructure as a service, platform as a service, software as a service. Again, apologies to the real techies in the room. This is a simplification. Infrastructure, as the name suggests, is hardware. It's the physical kit. It's the machines, the servers, the basic physical environment that you get in a data center, power supplies and all that kind of stuff. But really not much intelligence, not much software. Although there may be some very basic stuff you need to manage a dynamic public cloud environment. So hypervisor software, again, ask our techie later if you want to know how that works. Platform as a service is a level of complexity up from that, and it's likely to be not just hardware, but hardware with an operating system, a complete operating environment, in fact, that you can then run your applications on, perhaps even store your data on, but it's a level of complexity above. This is a made-up scenario. This is not a real record of an actual cloud negotiation. The participants are not representing their normal organizations. They are in character. So any resemblance to any real people or companies is purely incidental. And no animals were harmed. Oh, so you don't need that bit. Okay. Right, over to you. If you could just introduce who you are in character, please. Thank you.
Thank you.
Hi, I'm the IT manager. So size, scale, cheaper, faster, and hopefully it'll work when we implement it are key to my business.
I'm Helen Gordon. I'm the CEO of Acme, and I care about shareholder return and reputation.
I'm the DP manager. Obviously, I'm here to uphold privacy, but let's hope if I win the game and drive through that.
Okay, so Mark, thank you for sharing with me your paper on the your proposal on why we should move to clouds this financial year. I have to say the paper looks pretty compelling to me. I've only read the executive summary, so I wanted to just go through a few points with you. You know, you mentioned in there cost savings. I mean, as an organisation, we've committed to bring down our overheads by 15% next year. And I don't know if this is a typo, but you've mentioned 30 to 40% cost savings. Is that?
Absolutely,
serious?
Helen. This is where I think we need to go. If you looked in the main body of the report, but I know you're really busy, and I don't like to bore you with details too much, you would have found that there's some good benchmark data there that really reinforces my belief this is where we need to go. All our competitors are doing this. We need to do this to maintain our market position. It's a bit of a no-brainer.
I mean, I'm on board. I mean, I very compelling. I guess when I see those numbers, I'm asking myself, you know, is this too good to be true? You know?
No, I think it's absolutely a robust, solid case. We did some research. We looked at a few things using Google, and we got some results.
Good research.
You know,
yeah.
I'm pretty convinced that this is what you want from your shareholders and the objectives you've got this year.
Well, it sounds like you've done your homework there, Mark. Could you just, I just wanted to talk to you a little bit more about, well, actually, Raji, you've turned up, so that's great. We'll talk to you in a minute about risk, because I noticed you didn't mention risk in your papers, so we'll let Raji have a moment on that in a minute. We've got the executive committee meeting. coming up in September, and I'd love to be able to share that number with them. Could you do a little bit more work on getting some granular detail on those numbers? Because if you're talking about sustainable benefit to the business of that kind of saving, that is fantastic in terms of reinvestment in our high growth markets. And I can see that that team meeting that you wanted to do in Vegas could be coming up next year if we can pull this off.
Yeah, I'd be more than happy to cancel my vacation and work over that next weekend. I think it's that important.
So our first example here is the kind of thing that's happened to quite a large number of companies at this point. So I don't even have to call it an anonymized example of something real. It's an anonymized example of probably 50 real things. But essentially, one of the things that hackers are after, not the only thing, but one of the things essentially is to make money. And one of the easiest ways to do that is to steal credit card data. And if you pause and think about it for a second, one thing that's kind of scary about this is that this isn't a problem that affects just the banks. It's a problem that affects almost any, or basically any company that takes credit cards, which is to say almost any consumer-facing company. The hackers have gotten much smarter over the years, so they don't necessarily go and target the largest companies, though they've been known to. They'll also target sort of medium-sized companies, your regular high street company that might have a dozen branches, probably has tens of thousands of credit cards, maybe more. And there's a very sophisticated trading system that exists on the internet for people who are in the business of buying and selling credit cards.
Obviously, this is one where the harm is, seems imminent, right? That someone's credit card, data could be used. So, you do want to get right on it. And what you see is, I've never had a client that they really are trying to keep this secret, right? If they're in the retail side of things, their customers are their treasure, and they know that, and they want to get the information out, but they want to get the right information out. And there can be debate about whether you're just going to, help tell them how to put flags on their credit files so that they, get an alert if there seems to be suspicious activity, or whether you're going to go ahead and purchase monitoring of their credit reports on their behalf. So there can be discussion about that. In the States, anyway, this has become very much a commoditized area of work. There are professional companies that handle all the notices for you. Most companies have cyber policies, and you get a data breach coach for free, and they kind of help you figure out how to respond to all these things. And you can play a lot of games if you want with how this particular jurisdiction defines a breach and what the trigger is, and is there enough harm here to fool around. In my experience, honestly, the retail companies are happy to give this information out. They're not trying to hide it. They're willing. I mean, there's enough of it going on. Maybe that they're comfortable with it now, and they want to be told how to do it. Well, can it be by email? Can I do publication? What content, and they wish it would just be one uniform national or worldwide standard.